Welcome back to the Contracts Review. We're going to talk about contract interpretation. And we covered Chapter 7 in the beginning of second semester after we had discussed whether a contract was formed. So we're going to begin by assuming that there is in fact a contract, although as we'll see throughout the discussion, there are some issues with contract interpretation which relate to whether or not the contract was sufficiently definite. But we'll assume it was formed, which means we have mutual acceptance, offer, mutual assent, meaning offer and acceptance, consideration, or an alternative such as promissory estoppel or promissory restitution, and there are no defenses such as the statute of frauds, mistake, misrepresentation, or another similar issue. Now we're going to turn to the issue of what does a contract mean. We're going to begin by looking at the contract. We always are going to begin by looking at the contract and reviewing the written terms. What do the written terms say intrinsically? When we actually look at the four corners of the document, what do those words say? And are we going to admit extrinsic evidence, outside evidence, to inform our understanding of what those terms mean? There might be terms that are not written down. Are we going to include those in the agreement? That's the Parole evidence rule. Are we going to admit extrinsic evidence of additional terms, not just to clarify the meaning of terms, but to change or add terms? We might also add terms that are implied either in fact or in law, things that were not said, not in a prior oral agreement, never actually spoken, or not part of an agreement or purported agreement, but would be implied either by what the parties actually intended and reasonably would have thought would have been included in the contract and the terms and the understanding, or implied by law. And the major one that is always implied by law is the duty of good faith and fair dealing, which also pertains to our study of conditions. A condition is different than a promise because if a condition does not occur, the other party does not have to perform. And so we interpret contract terms to determine whether they are terms, whether they are promises, or whether they are conditions. And if they are conditions, a duty of good faith applies to the party who holds that condition, that they have to bring that into existence or make reasonable efforts to bring it into existence. We began our study with the Frugaliment case, which asks a very basic question: what is chicken? Is the word chicken ambiguous? And it really made the point that even ordinary words can pose chicken issues. So these are the Chicken Sisters, and this is Julia Child, who introduces Miss Broiler, Miss Fryer, Miss Roaster, Miss Caponette, Miss Stewer, and old Madam Hen. Thank you very much, Dana. Appreciate that. And this is relevant. The reason that we care about the Chicken Sisters is it evidences that chicken is in fact ambiguous. There is not one chicken. But we have a contract here, a contract between parties where one party asked for chicken, the other party delivered one particular type of chicken, an inexpensive chicken. The party wanted the more expensive chicken. And this really just started our conversation to elevate our understanding of ambiguity. Right? Ambiguity can exist either patently or latently. Ambiguity might exist on the face of the document, that's patent. You can read the document and it's not clear. There might be some terms that are different. It might use the same term differently, and that creates a patent ambiguity. Or there might be a latent ambiguity. You may not know that chicken is ambiguous because you go to McDonald's, you get a chicken sandwich, you know exactly what to expect. But if you are in a commercial relationship with a chicken seller and a chicken buyer, you don't know what to expect. You don't know if you're getting a stewer, a broiler, or a fryer when you say chicken, so you need to specify. The term has an ambiguity. Right, so that really just set up our conversation. The Frugaliment case is one of those famous classic cases where your law professor tends to dress up as a chicken. And it gives us an excuse to apply the canons of construction. And when I say canons, I do not mean this type of canon. Canon spelled with one N, not two N's. The canons of construction are a series of rules. I'll present 14 of these rules that tell us how to disambiguify ambiguous terms. I'll put them up here as I go through them. So we discussed 13 plus 1 canons. The reason that last one is sort of our plus 1 is because it's more of a policy rule than a semantic rule. And that rule is construction against the drafter, our rule of last resort. So our semantic rules relate to understanding the intrinsic meaning of words. We're going to actually read the four corners of the document. That's our first step in contract analysis. What does this contract actually say? And when we do that, we're going to apply these 13 canons as we go through that to try to evaluate the meaning. Now, I listed these in order 1 to 13. They are not hierarchical. right? We do not necessarily say 11 is preferred over 3, but these are just one way to understand and reference the 13 canons of construction that are typically applied, both, by the way, in our study of contracts and in our evaluation of statutes. So we begin with the dictionary meaning. Ordinary people use ordinary words, and the ordinary word is what you find in the dictionary, but not all dictionaries are going to work, especially when we have technical parties. Technical parties might use words specifically. The understanding of chicken, for example, among the parties in Fregalement had a technical meaning. And when parties are both in the technical field, when they are both in the technical field, and so they both intend to use the technical meaning, courts will imply a technical meaning. We're going to try to incorporate the entire writing and make sure that that word makes sense across the entire writing. One transaction could include many documents. A term may appear many times. Courts will look at all the documents together as part of one deal and try to interpret them consistently. And in doing so, we give force to every term. If there is an interpretation that gives force to every term, meaning to everything that is written, we will prefer that over an interpretation that eviscerates the meaning of any one given term. So if we have a contract that says vessel to be loaded in turn and vessel to be loaded promptly, we could understand that to mean when I get there and I'm 14th in line, I actually get to go to the front because I get to be loaded promptly. But that eviscerates the meaning of loaded in turn. A better understanding is, no, when it's your turn, number 14, we'll load your vessel promptly. That gives meaning to every term. We're going to prefer specific terms over general ones. So when terms are given greater weight when they're specific, because we believe parties have paid more attention to them. And it shows, again, their intentionality. All of this is about understanding the intention of the parties through what they wrote down. So we will prefer specific terms, and we will try to interpret those words consistently, meaning the same word has the same meaning. Don't get creative in your contract drafting. The same word, the same meaning. We're not going to take out the thesaurus and try to come up with clever, different ways of saying something. If we use a different word, therefore, we imply that it has a different meaning. So we assume that parties use the same word consistently, the same word, the same meaning, a different word, a different meaning. And we take that meaning out of context, or rather, we put it in context, not out of context. A word on its own does not have much meaning. It's one reason computers are very bad at understanding language. They're getting better at it, but they're still worse at it than people because we understand words in a broader context, social norms, etc., etc. If I say cleave, what do I mean? Cleave has two meanings. That word out of context could mean to stick to or to cut in half. And the way that we understand what cleave means has to be in the context. If we're in a butcher's shop, cleave means one thing. If we're talking about belief in a religion, cleave means another thing. Additionally, we try to use specific words to limit general lists, and this might be counterintuitive for some of you. When parties add a general term after a list of particular items, they are evidencing they're thinking of those as a single category, and then we go to what that category is. We think about that category and we limit it. So specific words limit general lists. So a phrase, pigs, horses, cattle, sheep, goats, and other farm animals, seems to have general language, any other farm animals, but we have those specific terms. What is common to all of those animals, horses, cattle, sheep, pigs, and goats? Well, they're all four-legged, hoofed mammals, right? So we could colorably argue that that list excludes chickens, which are two-legged non-mammals. We are going to prefer added terms over boilerplate and handwriting over printed terms, again, because we're trying to get to the intent of the parties. Boilerplate is something found in all contracts, but specific terms, added terms, terms the parties deliberately put in there, more likely to evidence what they actually meant. The expression of one implies exclusion of the others. So if we write a category, if we write a list of things down and something is missing from that list, something that would you expect to be implied in that list. If we say all the pigs, goats, and horses, and we do not say cows, cows would be included in that list. The fact that it's not there implies its exclusion. We also interpret contracts to avoid illegality. If there is a contract that you could calculate interest in two different ways, one way, the interest rate would be higher than is allowed by law. Another way of interpreting the contract, the interest rate is permissible by law, not usurious. We're going to interpret that contract to avoid illegality, and we're going to follow the rules of grammar. And, or, but, not, shall. Or generally broadens the meaning of things. It includes more in the list, and will usually constrain it because we have that conjunctive, not the disjunctive. So we're going to follow rules of grammar. And one of those rules of grammar that is specifically mentioned in some of the work on this is the last antecedent rule. And so this, again, may be a counterintuitive one, but the expectation of courts, at least applied by this canon, is that parties write grammatically and put clauses closest to the phrase being modified. This isn't Latin, where you can have the modifier anywhere in the sentence. This is English, where the modifier is expected to be closest to what it modifies. So we're going to interpret a modifying phrase at the end of the list as referring only to the last item in the list. We have a modifying phrase at the end of a list. We're going to interpret it as applying only to the last item in the list. And finally, when all else fails, we wave our magic wands and say, contra preferentum, I can't understand this contract, but you, the drafter, you who had the power, you who had the asymmetric bargaining power in this relationship, we're going to construe it against you, right? Because we don't want a policy that encourages people to draft things badly. We want a policy that's going to favor the person with the lesser bargaining power or where there's an ambiguity and encourage people to write well. Now, this was all about understanding intrinsic evidence, reading the four corners of the contract. What do the words actually say? But courts will also look beyond the contract to understand its terms. The UCC requires this in many cases, and it has a hierarchy, an order of operations by which one would look at this. First, we look at the express terms, the express written terms that are actually in the contract. In other words, the intrinsic evidence. I know it's a little confusing. Intrinsic are express terms, right? Extrinsic evidence are not actually expressed in the contract, extrinsic. So express terms, those are the actual writing. Express terms, that's the four corners of the document. That's what's intrinsic to it that you can get just from reading it, and they prevail. But if we can't take meaning from that, or if we result in our canons with ambiguity, the UCC then directs us to look at course of performance, which means how the parties performed under this contract. Course of performance is same parties, same contract. Course of performance is same parties, same contract. And if we can't get meaning from that, or if there has not been performance under this contract, we look at how these parties behaved under a different contract, and that is their course of dealing. Same parties, different contract. Course of dealing is same parties, different contract, and that's second in our order. And then we look at usage of trade, which is different parties, different contract. Usage of trade is different parties, different contract. We're clearly farther away from the party's intent, but when parties are part of a trade or organization, we understand that the usage of trade has some governance over the meaning that they may have intended. So we have these priorities then. We look at the word in context. We then incorporate any regulations that are incorporated by reference or any other document incorporated by reference, and the sensible operation. Those are all pertain to what is intrinsically in the contract. Incorporated regulations are kind of by magic. If we define a regulation as part of a contract, we incorporate it by reference, and we think about what would be sensible, what makes sense. And then after that, we look at preliminary negotiations, which are evidence of the party's intent for this contract, how the parties performed under this contract, how the parties performed under other contracts, and finally, the usage of trade. Now, it turns out that courts don't apply these consistently, and we read 3 different cases showing 3 different approaches to how courts will allow extrinsic evidence to inform the meaning of express terms in a contract. When will courts admit extrinsic evidence? In 3 cases, we saw 3 rules. The first rule, and these are all different. These are all different approaches, and the way to handle this is to discuss the policy reasons why a court may have taken one or another of these approaches. The first approach taken by C&A Construction is that a patently unambiguous contract will not allow extrinsic evidence. We stop there. If we're able to use the canons of construction to determine the meaning of a contract, we do not look for latent ambiguity. Now, PG&E took a different approach. They said that a contract cannot prove itself. It's impossible, right? Latent ambiguity means there is ambiguity outside of the contract, and they will admit extrinsic evidence to show there is a latent ambiguity and to resolve it. A latent ambiguity meaning something you would not see from reading the 4 corners. The PG&E case policy was a contract cannot prove itself. And the Nanacooley case really pushed the envelope and said that course of performance is always admissible, even if we have patent and latent unambiguity. So let's take a little bit closer look at all of these cases. What was going on in C&A Construction? This was a suit brought on behalf, for a deficient payment on a contract between 2 subcontractors. And whenever we have a contract interpretation question, we always have to first read the contract. What did this contract say? Let's take a moment and read it. It said things that were, well, potentially ambiguous. It is further agreed that the second subcontractor will receive $20,000 for supervision, which will be added to the actual cost figure. It is further agreed that the difference between actual cost and bid price will be divided as follows, blah, blah, blah. So the question here is, what is meant by this? Is this an ambiguous paragraph? It doesn't appear to the court to be ambiguous on its face. It says $20,000 will be added to actual cost. And we understand what cost means. We're going to open a dictionary. We're going to apply our canons of construction. Cost means how much it costs for the materials. The question here is, can you pay the person for his supervision on top of that? It appears that you cannot. It appears that supervision is counted in the $20,000, but the plaintiff wanted to be paid for his time spent on the job as a supervisor. He wanted to include his time spent on the job as part of the cost. Well, this actually does present a latent ambiguity because usually the owner of a project who would be paid $20,000 for supervision would have a cost of having a manager on site. And that on-site manager would earn a salary. And that salary would go toward cost of the project. And so that cost number would increase. Here, this is a small subcontractor. He did not have a separate manager. The manager and the owner were the same person. And so the court said, this is patently unambiguous. You don't get paid for the time you spent on the job. Now, I actually think the court made a mistake here because I also teach corporate law, and there is a difference between a corporate person and a natural person. And while the supervision went to the corporate person, there was a natural person on the job site charging a cost. But the court here took a fairly extreme view on one side and said that this is patently unambiguous. And since it's patently unambiguous, since we can understand it on its four corners, since the intrinsic evidence, what was written down, makes sense to us, we are not going to admit extrinsic evidence. We're not going to admit extrinsic evidence. And so the holding from CNA was a patently unambiguous contract will not admit extrinsic evidence. So that's one rule, one approach, and you should read the reasoning there to see how to argue it. On the other hand, we have PG&E versus G.W. Thomas. And here we have an agreement to replace a steam turbine. And the agreement to replace a steam turbine included an indemnity provision. Indemnity provision means you're going to protect someone from loss, damage, and harm. Let's look at that provision. When you're studying contract interpretation, you should always read the contract. The contract says, defendant agrees to perform the work at its own risk and expense and to indemnify the plaintiff against all loss. All loss sounds like all loss. That is not patently ambiguous. All loss is clear. All loss, damage, expense, and liability resulting from injury to property arising out of or any way connected with the performance of this contract. But there was a latent ambiguity because what else did the defendant do? To get insurance, to cover insurance for injury to property. Now, this doesn't make sense. If you're covering all of the damage, why do you also have to take out insurance? And here the defendant argued that what it was saying is in these contracts, it is typical that the indemnity provision does not include harm to your property, but to third parties' property. Now, it doesn't say that. It says all harm, all property arising out of the work. But they said that no, there is more to it. And in fact, during our course of dealing, during our prior contracts, it was understood that that third-party identification applied, that this was third-party identification. So what is the court going to do here? Is the court going to admit evidence of course of dealing, a type of extrinsic evidence? Yes. The PG&E holding was that this had a latent ambiguity, and we will take a first step. We will allow extrinsic evidence, outside evidence, to come in to show if there is an ambiguity in a contract, because a contract can never prove itself. Because the words on the paper do not have enough meaning. We can always admit extrinsic evidence to show a latent ambiguity. And if there is a latent ambiguity, we can use that extrinsic evidence to prove the meaning of the contract. This is the mainstream approach. Now we go even farther off the other side of the spectrum, and we take a look at our Hawaii case, Nanakuli Paving and Rock Company, where we again read the contract. This was a contract to provide asphalt. And it said Shell's, the contract to provide it would be at Shell's posted price at the time of delivery. This is the least ambiguous contract at all. There is nothing more clear than this. Posted price at the time of delivery, posted price capitalized, it's defined elsewhere in the contract. We know exactly what that means. It means at the, and at time of delivery, we know what that means, when they showed up with the asphalt. Right, so there is absolutely no ambiguity here, but Nanakuli argues that in Hawaii at the time there was something called price protection. Meaning that because the price of asphalt could go up and down volatilely because oil prices, asphalt's made out of oil, right? That's why Shell is producing it, also go up and down very frequently. mean that we have to apply this trade usage because they would be sometimes paying more for the asphalt than they would earn under a contract because the price would go up by the time they were ready to perform and they needed the asphalt. The contracting and the procurement process and the negotiations could happen years before the asphalt is delivered. And so the contract did not have any term for price protection, and they're going to say, we're going to admit that. Now, the parties had never done business together, so we don't have course of dealing, and they definitely had not performed this contract, so we don't have course of performance. The contract is unambiguous on its face, right? And there doesn't seem to be any ambiguity aside from that step 7 out of 7, trade usage, the last thing down on our list. But this court takes the most extreme approach and says course of performance, and in this case, trade usage is always admissible, and we're going to admit extrinsic evidence always, even when the document is not susceptible to another meaning. This is not susceptible to another meaning. This language is clear. And so an extreme view from courts is to say, no, we're going to admit extrinsic evidence anyway. But the mainline approach, let me move forward to our 3 different approaches, is found in P, G, and E, our middle-of-the-road approach, the approach that extrinsic evidence is admissible to prove a latent ambiguity, and when we find a latent ambiguity, then that extrinsic evidence can show the meaning of that term that could otherwise not be understood through the canons of construction. Right, so again, extrinsic evidence is the study of when courts are going to look beyond the contract to explain contract terms. And we're going to contrast that with parole evidence, which is admission of other agreements. So parole evidence is when courts look beyond the contract, not to understand the terms, not to explain the terms, not to give meaning to the terms, but to either add or to change a term. So when can evidence of additional terms from prior or contemporaneous oral or written agreements be entered into? And by the way, parole evidence, again, is not with an E. We're going to cut that E out. We're talking about P-A-R-O-L evidence, not your parole officer. So parole evidence rule bars evidence of prior negotiations that alter final written terms, prior or contemporaneous negotiations or other contracts that would alter final written terms, or evidence of prior negotiations that add terms to a complete and exclusive agreement. Now, that was some terminology I just threw at you, some jargon. We're going to break it down here. That jargon, again, is on the one hand looking at the UCC. We can have a final written expression in terms of common law, the partial integration, back to the UCC, or we can have a complete and exclusive statement, or in common law terms, a complete integration. So to clarify, a partial integration and a final written expression are the same thing. It's just a question of whether we're under the UCC, in which case we use the term final written expression, or if we're under the common law, in which case we talk about a partial integration. If we're under the UCC, we talk about a complete and exclusive statement. But that is the same thing as a complete integration. So we next need to understand what these terms are and when a document is collateral. So what does it mean to have something that is a final written expression? A final written expression means that the terms are final, but there could be additional terms that are not written down. Whereas a complete and exclusive statement means, like it says, that the contract contains everything you would expect to see. Now, one time that a contract will not contain everything you expect to see is when there are collateral agreements, something that is in addition to. So a complete and exclusive statement will contain all the terms you'd expect to see in that agreement, but there could be other agreements. There could be collateral agreements. And the collateral contract doctrine is the principle that in a dispute concerning a written contract, proof of a other, usually oral, but could be written, agreement will not be excluded under the parole evidence rule if the oral agreement is collateral, which means if it is independent of, if it is not inconsistent with, if it would not be expected to be included in that final or complete and exclusive writing. Oh, and by the way, I should have mentioned this right up front, going back to our slide here. Parole evidence only applies when you have a writing. It does not apply at all when there is merely an oral agreement. You need a writing, and then we look at whether that writing is a final integration or a complete and exclusive integration. Parole evidence only applies when you have a writing, and you're trying to admit additional or change the terms in that writing by evidence of contemporaneous or prior oral or written agreements. So we look at the Seagram's case to first understand what is collateral, because if it's collateral, it doesn't come in. A collateral contract is not going to be expected to be in another contract. That's the definition of collateral. A collateral agreement is separate from, but related to the contract at issue, but separate enough from that we would not expect it to be in that contract. And so it would not be found even in complete terms and exclusive terms, because it's not expected to be part of those terms. So the Seagram case dealt with this. And in the Seagram's case, Capital City Wholesale Distributor wanted to sell their distributor business back to Seagram's, the manufacturer, and they wanted to make this conditional. We'll go back to conditions. They didn't succeed in making it conditional. They want to make it conditional on an oral agreement to relocate the owner and his sons to a new distributor location in a different city. So this is the key fact pattern that will give you parole evidence rule issues, right? We have a written agreement. That written agreement is a sale of a company. It's a major agreement, right? I showed you my merger agreement when it came in, a stack of documents this tall, a bunch of signatures prepared by lawyers for millions of dollars, right? So we understand that we do have a complete integration. On the one hand, the question is, was the agreement to relocate this family, should we find that in a merger agreement? And the court said no, we would not expect to find an agreement to relocate half of the shareholders to another city in a merger agreement pertaining to the sale of assets. It actually was not a merger agreement, it was an asset sale, to be more specific, so it would have been an asset purchase agreement. But an asset purchase agreement is what it sounds like. It's a sale of assets. It would not be expected to contain a collateral agreement. And so here, what is the rule there? The parole evidence rule would bar evidence of terms that contradict a partial integration or add terms to a complete integration, but it does not apply if we would not expect those terms to be included, and they were not to be included here. And so we have to do a factual analysis in all of these cases. It's a very fact-intensive course of study, contract interpretation. The parole evidence rule does not apply to collateral or ancillary agreements. This is one example of a collateral or ancillary agreement, and we find that by making arguments that parties would not expect these terms to be in that writing. These terms would not be expected to be in that writing, so these terms are collateral to that writing. They are separate from it, and so even if that writing is complete and exclusive, don't worry about it, because it wouldn't have been in there anyway. It's not missing, it is separate. So that's one way out of the parole evidence rule, is if we find that we have a collateral agreement. Now let's talk about the parole evidence rule in a little bit more detail. Let's say the agreement that we have is not collateral. We have something that would be expected to be in the same contract. Now we have to do the analysis of whether the writing is final or complete and exclusive, whether it is partially or completely integrated, to use the terms from the restatement. And the restatement says a binding, and it doesn't use the word partial, but again, think of your Venn diagram. We have integrated and then we have completely integrated. I'm referring to it as partially integrated and completely integrated for simplicity. So I added the word partial here to the restatement. A binding, partially integrated agreement discharges prior agreements to the extent it is inconsistent. So a final writing, a partial integration, discharges prior or contemporaneous oral or written agreements to the extent that they are inconsistent. Then if we go one step further in, if we zoom into our complete integration, a binding, completely integrated agreement discharges prior agreements to the extent they are within its scope, because it should be included in that contract. And since it is not there, we're going to assume the parties didn't mean it. It goes back to our canons of construction, that the fact that it is omitted has meaning. Every term has meaning, every omission has meaning. And if we would expect it to be there and it's not, then that omission has meaning. An integrated agreement is a writing or writing constituting a final expression, so it defines integrated agreement to have the same concept, and then a complete and exclusive a complete integration is again complete and exclusive, again showing you that the terms from the UCC and from the restatement have the same meaning, just different terminology. But the key thing is to figure out when one is one and one is the other. When is a document integrated at all? Because there are three possibilities. A writing can be not integrated, meaning it's not final. It could have draft written on the top. It could be not signed, not dated. There could be evidence, right? Evidence that it was not intended to be the final terms. It might say on the top, document for preliminary negotiation purposes only. It might say on it, not final. It might say on it, draft, right? That is a not integrated agreement. And what is the effect of an unintegrated agreement? It has no effect on exclusion of other evidence because, in fact, it says right there, these aren't the final terms. courts, go ahead and look for final terms elsewhere. On the other hand, it could appear to be final. It could appear to have final terms on it, the terms you'd expect to see in a final agreement. It might be signed. It might be dated. It might say final agreement. It might be emailed with the subject line, final agreement for your approval. And then it also might contain a phrase, a particular clause, a merger clause, an integration clause, a statement that the document itself says this is a complete and exclusive statement. And that will be the best evidence that it is complete and exclusive. Now, this is not dispositive. We're going to look at some cases where even though there was a merger agreement, it was not complete and exclusive. Let's take a look at 3 different cases to see what is the effect of a merger clause on determining a integration. And again, the way that first step needs to be, is this partially integrated at all? Is it integrated at all? If it says draft, if it says preliminary negotiations, if there are 17 copies and they all say different things and none of them are signed, it's probably not integrated. We need to at least have an integration, and then we ask, does this integration have a merger clause, and what is the effect of that merger clause? Because very unlikely for a court to find a document is completely integrated without express language of the parties saying so. The omission of a merger clause can also be evidence. So we have 3 different approaches here. Middletown Concrete said a merger clause is conclusive evidence unless contradicted by intrinsic evidence. We're going to look at the document itself to see if it is internally contradictory. United Auto Workers said a merger clause is always conclusive. If it says complete and exclusive, it means complete and exclusive. We're going to go ahead and honor the party's intent, kind of like CNA Construction, really honoring what the contract said when it's unambiguous. And our third approach, which is kind of like our Nanacooley case, or really our outlier case, where we're pushing the boundaries of the doctrine, a merger clause is not conclusive when contradicted by extrinsic evidence. So we're going to admit extrinsic evidence even when there's no ambiguity. Kind of like Nanacooley, even though the document was not susceptible to another meaning, we're going to admit that in extreme cases. So we have, again, our kind of, in fact, United Auto Workers here, even though that's a bit harsher, is our mainline case. Usually a merger clause, especially between parties of equal bargaining power who are sophisticated, will be conclusive. Right? But some courts will also allow it to be contradicted by intrinsic evidence. That's not necessarily different. I mean, that's really saying that there's something wrong with the contract itself. Let's take a look at Middletown, what happened here. This is the pipe making case, right? We have the Saturn machine and the Neptune machine, and these machines were supposed to make pipe at a certain rate, and one party wanted to have those rates guaranteed, and the other party did not want to provide guarantees. Expressly disclaimed any guarantees, any warranties that the pipes would be produced at a certain rate. They didn't want to say their machines could make pipes at a particular rate, and so they wrote something in the contract. When doing contract interpretation, you should always read the contract, and that is never more important than the merger clause. To determine there's a complete and exclusive statement, we need to look at the merger clause. If it's not there, that's very good evidence. It is merely final at best. If there is a merger clause, we have to read it. And what does that merger clause say? I hid that slide, sorry. What does the merger clause here say, right? This is the case of Middletown Concrete. We, Hydrotile, hereby offer for a limited period of 30 days following the date of the items described below and or in the specifications of any consisting of blank pages. This offer is subject to terms and conditions contained on this and the other side hereof, and in said specifications, if any, and no others whatsoever. And on that page, in this document, it says that this is, in fact, the only terms and conditions, right? It is limiting the contract, and so this is a merger clause. It doesn't read like a merger clause, but it says this offer is subject to the terms and conditions contained on this and the other side, if any, and to no others whatsoever. It's saying these are the only terms. Now, it could be written better. There are better written merger clauses, but you should be able to recognize this as a merger clause because it has the effect of a merger clause. It purports to exclude other prior or contemporaneous oral or written agreements from adding or changing the terms in this agreement. So was this merger clause effective? It looks very effective. In fact, if you looked at it on its face, it looks effective, but there was a problem. What was the problem in this case? The problem was they had 3 of these contracts. They had contracts number 146, 148, and 149, and there was also something called the acceptable performance letter. Now, the problem in this case was it was contradictory. You have 3 documents, and all of them say that they are the complete and exclusive agreement. One of our canons is to look at all the documents in a transaction as a whole. If 3 documents all purport to be the only document, none of them can be the only document. We can't preference one over the other. So the court says that even though they had a merger clause, this is an unusual case, kind of kind of getting you thinking about the meaning of a merger clause. The merger clause did not make sense on its face. It was intrinsically ambiguous. It had an intrinsic problem because you can't have three documents that are all different, that are all the only document. That just doesn't make sense. The court cannot call that a merger clause. However, it did find that these documents were at least final. So what happens to that acceptable performance letter where it guaranteed these production rates? One party wanted the guarantee, the other party didn't want to give the guarantee. Does the guarantee come in? No. The holding here is that the merger clause is going to be contradicted, but these documents were final, and the final document had a term that said there are no other warranties. So this was a bit of an unusual case. Go back and look at it, but it held that a merger clause, the overall holding, is a merger clause is conclusive unless in the unusual case it is contradicted by the documents itself. So again, we're going to give a lot of weight to a merger clause, but we see the outside of that doctrine where a merger clause was not effective because it was inherently, internally, intrinsically contradictory and did not make sense on its face. Still, though, the result turned out not to turn on that because the party's term was final, and this term in each contract said in this contract, right, the terms on the other side are the only terms, and that would have been contradicted by adding terms. In United Auto Workers, we had another case, right? We have a hotel which has been purchased, and so we have a change of ownership, and the prior owners, before selling the hotel, had a contract to hold a convention for the United Auto Workers Union. And this union had an oral agreement made at the time of the contract or prior to it, a contemporaneous or prior oral agreement that was not written down, not included in the agreement to rent the hotel, that the staff would be unionized. So this is a union, and they wanted union staff to provide services at this hotel. Well, the hotel was sold. The party who assumed ownership of the hotel was aware of the written contract. Why? Because it was written down. But they were not aware of this oral agreement. They weren't privy to it. They weren't part of that conversation. And so they didn't have union staff, and United Auto Workers said, okay, fine, you're breaching your contract. We're going to sue you, or we're not going to perform. We're going to refuse to perform because we're only going to go to a hotel that has a union staff. Now, in this case, did we have a merger agreement? We did have a merger clause here. We had a clear and conclusive merger clause. And so what is the result when we have a clear and conclusive merger clause? Again, the standard rule. This is the default rule. This is the common rule. The rule is that if there is a clear and conclusive, unambiguous merger clause, and there's no intrinsic evidence to contradict it, right? We only have one document. It says this is the complete and exclusive understanding of the parties. That's conclusive, and we stop there. We're not going to admit parole evidence. That's the purpose of the parole evidence rule. This is the mainline case for the mainstream approach, the general purpose of the parole evidence rule. It is designed to exclude that type of evidence. Let's look at the corner case then, Sierra Diesel, going back to 1971, I believe, where we have a mechanic that wants to purchase a bookkeeping machine, now today known as computers. Right? So he goes to a purveyor of bookkeeping machines and says, yeah, I'd like a bookkeeping machine that will do X, Y, and Z function, right? That'll keep track of my orders, that'll help me do my taxes, right? Now this person wasn't particularly savvy, right? They don't really know how to use one of these devices, and so they go and they take the salesman's word, right? The salesman tells them, oh, it'll do everything you want, it's going to be fast, it's going to be perfect, it's going to be easy to use, you won't have any trouble, you're going to love the cup holder. And so the salesperson says all this stuff and then provides a contract that excludes all of that. And the contract says this is complete and exclusive integration. So the conversation where the salesman, who is an agent of the manufacturer, is promising this not very technologically savvy guy that it will work for him, then serves him up a contract that says everything I said doesn't count, you don't get any warranties that it will perform those functions, and it was a list of technical specifications that would make your grandma's head spin. And so he wasn't able to actually understand this. Now it had a merger clause, it was clear and unambiguous, just like in United Auto Workers. So do we get the same result? No, this is the corner case. This is the corner case where we actually have a clear, conclusive merger clause and a different result. Why? The court finds it would be unfair, I think. The court finds that this was taking advantage of someone, using a contract to get to pull the wool over someone's eyes because of unequal bargaining power, asymmetric information, inability to understand what was being written down. Now, this is an unusual case, but it is on the books, and so you can cite to it to say that a merger clause is not always conclusive where it's not what the parties would have intended. And here the court admits extrinsic evidence that the salesman sold him a bunch of BS in order to get him to buy the computer and then tried to limit his own liability for essentially deceiving an uninformed customer. And that's not going to fly. So we have three different rules. We have our beginning point, which is a merger clause is conclusive unless, which is unusual, it is contradicted by intrinsic evidence. We have our mainline case, once again, the heart of the doctrine, that a merger clause is conclusive. Here it says always conclusive. Read the dissent for the explanation of why that might not always be appropriate, but that is kind of our mainline rule that courts will give credence to the merger clause because we want to provide parties certainty. And when they wrote it down in a complete and exclusive agreement and they said as such, we're going to honor that unless we have an unusual case, right, where we have someone being taken advantage of or someone's using a contract that's something, maybe it's bordering on fraud, bordering on misrepresentation, and it would be fundamentally unfair. Oh, that's really going to take a while to get through. By the way, that was the chart that I suggested you fill out to understand that case. All right, let's talk about terms implied in circumstances. So now we've talked about two different kinds of terms. Express terms that are written down, express terms that are in the contract, and terms that were discussed but not written down. When did they come in? They come in when they're collateral. They come in when the document is not integrated. They come in when they do not contradict a final term, or they do not come in at all if there is a complete and exclusive integration. But we might also have terms that are implied that can come in. Terms can be either implied, and the reason that we have terms implied is because contracts are never complete. We don't account for every contingency under the sun when we write a complex agreement, and so we need to have an assumption that some terms are implied, and they can be implied in fact, meaning what the parties actually intended. They can be implied in law, which is what the courts will supply, or in the case of the UCC, we have gap filler statutory provisions, or the big one, right, implied in good faith. Terms that are implied in good faith. Terms implied by in fact were agreed to the parties implicitly. They don't fall under the Parole evidence rule. Terms implied in fact are not under the Parole evidence rule because they were not an agreement, right? There was not a conversation that said, okay, I promise to have union employees. And then later that wasn't honored because it wasn't written down. It was implied. Maybe they could have argued it was an implied term that United Auto Workers would expect union employees. That would have in fact been a better argument when you're faced with a complete and exclusive integration. A term implied in law will be selected by judges, and then good faith is one of those terms implied by law that has its own kind of subset and its own doctrine. All right, let's talk about the case of Fisher versus Congregation B'nai Yitzhak. And so here we have this image actually shows a conservative congregation, but in a traditional congregation under Orthodox Jewish law, there would be a mechitza, a separation, a barrier between men and women during services, during prayer. And this has been a tradition since the court says time immemorial, and this was at the time a Orthodox congregation. They had bylaws that said they were going to adhere to Orthodox law. A rabbi trained in Orthodox law came to them and offered to provide services on a high holy day, on a series of high holy days. And the question is, was there an implied term that those services would be performed under Orthodox law? It wasn't written down in the contract. The parties didn't think to put it down. But when he showed up, the room looked like this. It didn't have that mechitza. It didn't have that separation, and he refused to perform. He sued, saying that you didn't give me the circumstances I needed, and I need to be paid. It's too late for me to find other work. And so what is the result here? The result here is that that was a term implied in law. The term that an Orthodox rabbi would hold an Orthodox service in conformity with Orthodox law was implied in fact. For example, there was conversations that he had that showed that he had intended that. They had showed that the bylaws showed that. Now, this is not a rule that you would apply very often. It's an illustration. It's an analogy. So you use this case for your analogies, for your distinctions, cases that you might see. Right? The very fact-specific inquiry. What was implied in fact? Well, we have to look at all the facts and circumstances. What did the parties actually say and do? We have another case here where we have a term implied in law. In First National Bank of Lawrence versus Methodist Home for the Aged, we have Grandma Bertha, and Grandma Bertha loves this old age home, and she really wants to become a member there, but there's a probation period. So she gives them about $10,000 for lifetime membership, and then there's a 2-month probation period where she gets to try them out, and they get to try her out to make sure she's a good fit. Doesn't throw wild parties, little ragers. It's going to be disruptive to the rest of the residents. But, Bertha, on the other hand, she might not like their food, not like their air conditioning, whatever. And so she has, it's a lifetime commitment. So you have this probation period. Now, one thing the contract did not discuss, a term that was not written down and was never discussed, was what happens if she dies during the probation period. Well, you can understand why someone wouldn't really want to talk about their imminent death. It's not a very pleasant subject, so it wasn't discussed. And in fact, there was really no discussion about it, but she did in fact die during the probation period. The question is, if she dies during the probation period, who gets to keep her money? Does the estate get her money back? Is there a refund, as if she had said during the probation period, I don't want to stay here? Or if she dies during the probation period, is she now a lifetime member and the home gets to keep her money? You can imagine who argued what. So the court looks at this and says, well, we can't assess the intent of the parties because one of them is a little bit too dead to call to the witness stand. So how are we going to understand what the parties would have intended? We can imply that term in law. They look at a bunch of other contracts. They think about what a reasonable person in similar circumstances would do, and they supply the term. They supply the term that death during a probation period would make it impossible to become a lifetime resident. They effectively write that into the contract. It was never said between the parties. It was never necessarily expressed. We can't imagine what Bertha had to say on the matter, but they read other contracts that came to the same result. And Wood versus Lucy Lady Duff Gordon was a case that had to do with the duty of good faith and fair dealing, which is always implied in law. Now, Lucy had Lady Duff Gordon had an interesting argument. She was someone who was able to say what was cool and not cool, right? She was able to be a premature of fashion. And so someone wanted to put her name on certain dresses that he would produce, right? And she would approve them, and they would sell better because they would now have this couture label and feel. And she promised an exclusive agreement with this person, right, to Wood. He would say, okay, Wood, I'll exclusively brand my name on your clothing. But then she didn't do it. She decided that she was going to go ahead and give her approval to some other clothing lines. And he said, you breached. Now, she had an interesting argument that you'll have to recall from first semester. She said the contract was not enforceable because it was not supported by consideration. And why was the contract not supported by consideration? Well, Wood didn't have to actually do anything. He got 50% of the profits from what they sold, but he didn't have to make any dresses. He didn't have to say, this one, this one, this one, will you approve this? Will you approve that? He could have done nothing, and he would not have been in breach. Is that true? Is it true that a party has to do nothing and so they're not in breach? Well, if that is true, if a party doesn't have to actually do anything, that's an illusory promise. That's illusory consideration. Illusory consideration is not consideration. So that was a good argument on her part, but she lost. Why did she lose? Because the term that a profit-sharing partner or really a contract partner in any case needs to make reasonable efforts under a contract. Reasonable efforts, commercially reasonable efforts in good faith and fair dealing is implied in law. And so that brings us to our next subject matter. By the way, here's a bit of a preview on that, on what it means to have, what does it mean to have good faith? So good faith is implied in every contract. What is good faith? Some will describe it as an implied covenant, as just discussed here. It is also sort of an argument of last resort because you're, again, implying something in law and then having to determine what good faith means as opposed to pointing to express language. Some have called it honesty in fact. Some have called it commercially reasonable fair dealing. Some have said reasonable efforts. Others have said it's simply the absence of bad faith, not acting in bad faith. Not disrupting the contract unfairly. The restatement has something to say about this. It says that every contract imposes upon each party a duty of good faith and fair dealing in its performance and its enforcement. And the UCC says the same thing. So whatever law you're under, you have the duty of good faith and fair dealing. Every contract or duty within the UCC imposes an obligation of good faith in its performance and its enforcement. Good faith means honesty in fact and the observance of commercially reasonable standards of fair dealing. What does that mean? Well, it turns out it can mean different things in different circumstances. This subject in contract law is a very fact-specific inquiry. So let's look at our first case, Market Street, to try to understand what it means to have good faith in fair dealing in commercial relationships. So what happened in Market Street? J.C. Penney entered into a sale and leaseback. They owned a store, and instead of wanting to own that store, they wanted some cash. So how do you turn your store into cash without moving? You can sell it to someone else and then rent it from them. And now they're paying General Electric Capital Company a stream of income payments. They get to stay in their store, and they get that lump sum from the sale. Right? And then they assign that to Market Street Associates. So now Market Street Associates has this agreement where they have a lease from GE, and the lease had a specific term in it. The term in that lease said that if you need to improve this store, it can be expensive to improve a store. It can be hard, very hard, to improve a store you don't own. For those of you who have owned an apartment, even if you want to paint the walls, you probably have to put it back at the end. Some landlords will let you make improvements, but if you want to get financing for those improvements, I mean, who's going to give you a loan for $10,000 to redo the shower in an apartment that you lease? They're going to want to secure it by the property, and so you're going to have a very hard time securing financing. Realizing this, JCPenney and then through them Market Street Associates had a provision that said if we want to make improvements, we're going to ask you first. And if you refuse to make those improvements, we get to buy the property back. Right? If you refuse to make those improvements, you get to buy the property back. And so they send a letter to GE and they say, we want to make some improvements. Will you give us the financing? Now, what did they not do? They did not say, and by the way, read your contract, because the contract says if you don't give us the financing, our buyback provision becomes operative. Right? And so they didn't say that. They didn't mention this, in this case, paragraph 34, which had that buyback provision. And GE basically didn't pay any attention. They said, we really only like to do deals that are $7 million or more. We're not really concerned with little people like you. We're GE Capital. And so whatever, we're not going to pay much attention. And they didn't pay attention. And then what happens? They said, okay, fine, you didn't pay attention. Now sell us the property back. And in fact, the buyback provision would have been very cheap. They would have been able to, Market Street would have been able to buy the property at a really low price. Now that wasn't the purpose. They didn't write it that way, but they needed to buy it in order to do the improvements. So how does this case come out? Well, this case, the procedural posture means that we don't actually get to a disposition on the case, but the rule here as Judge Posner pronounces the rule in Market Street Associates, is a question in the matter of breach of an implied term of good faith. Here would be whether one party was trying to trick the other. Right? Good faith and fair dealing means not trying to trick your counterparty. You're in a relationship with your counterparty. You can't just trick them for your own benefit. So they have to go back on remand and ask, why did Market Street Associates fail to include paragraph 34? Why did they fail to include paragraph 34? Was it because they were trying to trick big old GE Capital? Kind of unlikely, right? GE should have its own team of lawyers. You'd think they'd read their contracts. Maybe GE was just too busy, right? And why was Market Street exercising this? Did they really need to make those improvements? Or were they trying to make excuses because they knew that the property was 3 times the value of the buyback provision? Right? What was the intention of the parties? Right? We have to get in their minds. We have to depose them, put them on the witness stand, ask them, what were you thinking when you didn't include paragraph 34 in your letter? Were you trying to trick them? Did you actually trick them? So the question in the matter of breach here, one question of whether the implied term of good faith and fair dealing is breached is whether one party tried to trick the other and succeeded in doing so. The matter of good faith and fair dealing comes up very often in output and requirement contracts. This is one specific area where we see good faith and fair dealing in output and requirement contracts. What is an output or requirement contract? It's when one person agrees to buy or an entire output, everything someone makes, or someone agrees to sell and purchase everything that they need, all the requirements. And the UCC 2-6 says a term which measures the quantity by which the output of the seller or the requirements of the buyer means actual requirements as may occur in good faith. Right? So the statute brings good faith right into these type of commercial agreements, except that no quantity unreasonably disproportionate to any stated estimate in the absence or stated estimate in a normal or otherwise comparable prior output requirements may be tendered or demanded. You have to use good faith in exercising your output and requirements contracts, right? And again, what is that? An output contract is where a producer agrees to sell and a buyer agrees to purchase an entire output. Everything you make, you get, right? Everything you make, you have to take. So an example here was our crushed toast company. What happened in New Crushed Toast Court? A defendant agreed to sell and plaintiff agreed to buy all the breadcrumbs produced by the seller at his factory at Thames Street in Brooklyn during a period. And now defendant stopped producing breadcrumbs at 6 cents a unit, right? So just stopped producing them and said, okay, I don't make any breadcrumbs, so I'm not selling you any breadcrumbs. My output is 0, and so you get 0. Now, why did they do that? They did that apparently because it was uneconomical. They asked for more money. They didn't make any efforts to improve their facility. They wanted to focus their business on something else. Was this in good faith? No, this was not in good faith. They reduced their output to 0 just to make more money. They wanted to make more money. They, in fact, asked for more money. They said, we'll keep making the breadcrumbs for a penny more per unit. You can't do that. You're in a relationship with a contract counterparty. Crushed Bread was in a relationship with the plaintiff, and so it was not able to reduce its output to zero in order to screw them out of breadcrumbs, and to try to jack up the price of breadcrumbs, right? So that doesn't work. Now, what is a requirement contract? That's when a buyer agrees to purchase as much as it needs from a particular supplier. You don't know how much you need. You're in a hot dog eating contest. You don't know how many hot dogs you can eat, but you agree that you'll pay for all the hot dogs you can eat in an hour. That means you have an obligation to eat as many hot dogs as you can, by the way. So let me give you a more concrete example. So here we have defendant agreed to sell and plaintiff agreed to buy all of defendant's heating fuel oil, right? Heating fuel oil for a price of $2.14 a barrel, and estimated, they actually had an estimate, go back to the UCC, it talks about you can't be totally out of whack with your estimates. They said they'd need about 1.7 million barrels a year. That's a lot of barrels. It's a lot of barrels, it's a lot of heating oil. Now what happens to the price of oil? It went up to $4 a barrel. They got a smoking deal. They're paying $2.14 for something worth $4. So they think, I could resell this. I could buy this oil and I could sell, even with transactions cost, if it's worth $4 on the market, I'll buy it for $2.14. I'll sell it myself. I'll make a mint. They weren't using this for their heating. They were buying this. This was not what they required for their good faith operations. They were buying this in order to resell it. And so what do the courts say? You can't do that. That's a breach of the duty of good faith and fair dealing. That's not what you actually needed. You didn't purchase this oil in order to heat your buildings. You didn't buy more oil because it was a cold winter. You bought it in order to resell it. And that's not what the contract was about. That breaches the duty of good faith and fair dealing in requirements contracts. So to summarize there, quantity is usually a required term. But sometimes contracts do not permit for quantity to be in there because you just don't know how much you can make. You don't know how much you'll need. You don't know how many hot dogs you're going to eat. You don't know how fast you can crank up the chocolates conveyor belt. You're not sure how much you can output, how much you'll require. And so you just can't include quantity. Quantity is usually a required term, but sometimes you can avoid it when you have an output requirements contract, but then you need the duty of good faith and fair dealing to protect the parties from having an unreasonable request for more than what they need for their commercial requirements being purchased or sold. The duty of good faith and fair dealing also pertains to termination clauses, another specific application of that general principle from Lucy Lady Duff Gordon that good faith and fair dealing is implied in all contracts. So we have different types of termination. We can terminate for cause, or as we'll see here, terminate for convenience. And even if a contract does not provide for termination, that may be an implied term. And in all of these cases, cause, convenience, and implied by law, we have the duty of good faith and fair dealing in this as in all other contracts. Termination rights are subject to good faith and fair dealing. And we can turn to Lady Duff Gordon for the historical approach or look forward to Kestar for an example of where this was not met. Now, the problem with termination clauses is that if you could terminate at any time for any reason or no reason, you don't really have a contract because you don't have to perform. If I can cancel a contract, if I make a contract to pick you up and take you to school every day, right, but I can cancel at any time for any reason or no reason, and the very next day, before I pick you up, I call and I cancel, did we actually have a contract, right? Well, no, not really. That was really an illusory contract. We didn't actually have a deal because I didn't have to do anything. My consideration was illusory. And so in order to avoid having an illusory contract, in order to avoid the Lucy Lady Duff Gordon argument where she has an illusory contract and does not have to perform her exclusive, we need to find a way to make that term have meaning. Where does that meaning come from? That comes from the duty of good faith and fair dealing. So this contract was to install carpeting. And it was a very complicated case. There was paragraph 12 that worked with paragraph 14, 7, 13, 16. Bottom line is the contract had a termination clause. It had a termination for cause and a termination for convenience clause. And they terminated for convenience basically because while they were in a contract relationship, while that Kestar Builders was in a relationship with CB Flooring, they were going behind their back. They were going behind their back and they were seeing if they can get a better price for the same job. And when they found a better price, they terminated for convenience. Now, it is more convenient to pay less, I guess, but is it a breach of the duty of good faith and fair dealing to breach a contract simply because you can get a lower price? Yes, it is. Yes, it is. That is inherently a breach of the duty of good faith and fair dealing. Is a breach of the duty of good faith and fair dealing, Kestar or CB Flooring holds, is a breach of the duty of good faith and fair dealing for a party to terminate simply to shop around for a better price. That's not what the termination clause there was for. What could it have been for? Well, maybe they didn't get financing on the building and they no longer needed carpet at all because they weren't building apartments. right? That isn't cause. That isn't CB Flooring doing something bad or fraudulent, right? Maybe the market conditions change, or maybe people's tastes change, and they decide they didn't want carpet at all. They needed tile. They needed hardwood floors. And CB Flooring couldn't provide those kind of services because they were a carpeting company. Those are examples of where it might have been appropriate convenience. But simply to cheat on your partner, on your contract partner, go around their back to get a better price, that's not in accord with the duty of good faith and fair dealing. Something similar happened in Alcoa. Now here, we have Alcoa in a relationship with Bacalum based on an oral agreement. And the oral agreement did not have a termination clause in it, but essentially they said, okay, Bacalum, you can sell in New Jersey our aluminum siding, and we'll give you an exclusive. An exclusive is very valuable because you don't have to compete with other Alcoa dealers for best prices on Alcoa siding. If you want Alcoa siding, you come to Bacalum, and that's the only game in town. So that's pretty useful to hold. But what happened here? So Alcoa is in a relationship with Bacalum, and in fact is encouraging Bacalum to make investments based on that relationship, encouraging them to buy a bigger warehouse to keep all this stuff. And then out of the blue they say, oh, by the way, your termination, your exclusive is terminated as of today. As of today, right? No notice, right? No warning. And they decided this years ago, and they went behind Bacalum's back and talked to other distributors. Would you like to distribute our product in New Jersey? Would you like to distribute our product in New Jersey? Right? They went behind their back. They were effectively cheating on their contract partner, looking for a better price, looking for more distributors, violating the terms of their exclusive. Now, this contract was oral, and it did not have a termination clause, but they did argue successfully that this contract, as most contracts in commercial dealings, had a termination clause implied by law. This was not a joint venture that was meant to go on in perpetuity. This was not an acquisition of Bacalum. This was not a marriage, let's say. This was a relationship that was meant to last a set period of time. We didn't know how much time based on the oral agreement, but there was, in fact, a term implied in the contract, either in fact or in law. The court didn't reach that, but certainly was implied that termination is available. But that termination clause, just like the prior one, just like all termination clauses, is subject to a duty of good faith and fair dealing. And that means that the termination clause has to be exercised in good faith, and it's not when you go around their back, and it has to have other terms in it, like reasonable notice. So the fact that they had misled their contract counterparty into investing in a new warehouse extended the period of time which notice would be needed. And the court held that it is a breach of the duty of good faith to terminate a contract without reasonable notice to the party, where the purpose is to cheat the party out of the fruits of the contract. Right? Oh, you're going to get wealthy off this one. Go ahead and get that bigger factory. We're going to sell a lot of siding in New Jersey, just not through you. Right? They were cheating them out of the fruits of this contract, and in fact put them in a position where they had a lease they could not afford. So let's talk about express conditions next, because express conditions are part of contract interpretation, but express conditions begin to lead us into the discussion about contract performance. Because express conditions change the performance that's required by one party when a condition is not performed. What is a condition? A condition is a future and uncertain event, something that may or may not occur, on which the existence or extent of an obligation or liability depends, an uncertain act or event that triggers or negates a duty to perform. It's like a switch that either turns on or off another party's contractual obligations. If a contract calls for a condition, and that condition does not come to pass, a condition precedent does not come to pass, the other party does not have to perform duties related to that condition. A couple examples here, right? So a construction company's duty to perform could be subject to a favorable ruling at a planning commission. A securities purchase agreement could be contingent on an expert determining that that will generate tax consequences. A home buyer could close conditional on ability to obtain a mortgage at specified financing. An insurance company has to pay, provided that notice is provided within a certain period. And so what is common to all these? We have language here, and again, we're interpreting contracts. We're interpreting contracts to understand the consequence of them. And this type of language, subject to, contingent on, conditional on, provided that, these are words that help us understand the meaning of this term is a condition and not a promise. Right? How does this work? This functions that parties, they have a commitment, right? They have a contract, and so it's not an illusory contract, but that duty doesn't spring into existence unless and until a condition comes to pass. And there's also, we have three different concepts here. We have then promises, Promises have to be performed regardless, mutual and independent promises. We have conditions. A condition, if it does not occur, means that another party does not have a duty, or a conditional promise, which we'll see in one of our cases, which must occur. It's a promise, but it also turns on or off the other party's duty. And when we talk about conditions, we talk about conditions precedent, something that must occur for another person's duty to exist. And we also talk about conditions subsequent, something that if it occurs, it extinguishes, right? It puts water on that fire. It terminates a duty. So a condition can either trigger a duty, and when it triggers a duty, when it turns it on, when it occurs, that is a condition precedent. When it terminates a duty, when it turns it off, that is a condition subsequent. So what was the case of Morrison v. Baer about? This was about a term about fixing a cracked heat exchanger, when selling a house. So defendant contract to sell a house to plaintiff. And the contract had, in the provisions called special conditions, right, it said that defendant had to provide plaintiff with a repair bill. Now we read the contract first, and the fact that it was located in a section called conditions really helps our analysis here. And the contract said you need to provide a repair bill for the heat exchanger. The defendant produced a repair bill, but the repair bill said the heat exchanger wasn't fixed. Okay, that was a little bit of game playing here. That was sort of interesting. That stood for the point that, sure, the contract said produce a bill, but the court interpreted the party's intent as the bill saying the exchanger was fixed, not a bill saying I didn't do anything. Right? That was kind of like good faith and fair dealing was not committed there. So what happened here? What happened was the heat exchanger was not fixed, and the court found this was a condition. What happens when a condition is not performed? When a condition is not satisfied, the other party is excused. The other party does not have to perform, but the other party cannot sue. He wanted to sue for the value of the house less the value of the heat exchanger, or for specific performance on the sale of the house for a lower price. You can't do that. You have two choices when a condition is not performed. You can either waive the condition and close over the condition, or you can refuse to perform your obligation, but you cannot sue for breach because failure to perform a condition does not constitute a breach, although, as we'll see, you have a duty of good faith and fair dealing to make commercially reasonable efforts to make a condition come about. Apparently he made those efforts, the condition did not come about, and so the duty to close in the house was extinguished. In International Rotterdam, we had a contract to sell 95,600 pockets of rice. Whatever pockets of rice are, we have a duty to sell them based on the contract. We have an obligation, but that is contingent on, right? Notice, we had to say, where do you want us to ship the rice to? So the buyer had a condition, held a condition, right, that said, had an obligation to provide notice, and said, until that notice is provided, delivery does not have to take place. And that had to happen before December 17th because the shipment had to happen before the end of the year, and the shipment took 2 weeks. But the bottom line here was that we had a contract that said, I will sell you rice, and you will provide me notice of where to ship it to within the time period that I can actually meet the delivery. Because if you don't provide me notice in time, I can't deliver rice without knowing an address. So the court interpreted this to be a conditional promise. Why was this a conditional promise? Well, because there was a contract. I'm going to sell you rice, you're going to buy it. I'm going to promise to sell you rice, and you're going to promise to tell me where to ship it to before the deadline. Right? So it was a promise in that regard, but also it was a condition. It was a condition because how can you ship rice when you don't know where you're shipping it to? So my duty to ship you rice is contingent on you telling me where to ship it to. Right? Without providing that notice, I don't know where that rice is going. And so this held that when a conditional promise is not satisfied, the other party does not have to perform, and it could sue, because we can sue for a breach of a promise. It's a promissory condition. It was not performed, so we can sue for failure to provide notice. Why was there no suit in this case? Because they ended up selling the rice for more money. And so there are no damages. So the other party can sue, but as we'll learn in Chapter 9, you can only sue when there are damages, when there is harm. And here there was no harm, but the performance of shipping the rice was excused because the condition did not occur. In Renabes v. Hodges, we had plaintiff enter into an apartment purchase agreement, and it had two standard conditions. So one thing we learn is that in these type of contracts, there are some conditions that are very standard. One would be the financing, and one would be the inspection contingency, meaning that you agree to purchase the house, and you agree to get an inspection, but if you don't like how the inspection came out, for example, there's a cracked foundation, there's a leaking roof, there's a cracked heat exchanger, right, and you're not very handy, and so you don't want to invest in this, you don't have to buy the house. It might show the house is not worth it. You go into the house, you find that it has $10,000 of termite damage. The house is no longer worth $100,000. You don't have to buy it because you can exercise your contingency. Right? You can say, I got the inspection, the report was bad, and I'm going to exercise that. So what happened here? Well, we have a time of the essence here. These conditions have to operate within a certain time. And so what we learn here is that express conditions have to, we have two holdings here. Let me start with the first one, since I don't have a slide on it. One of the conditions here that's fundamental, one of the holdings here is that when you have a condition that has a time limit, we have to fall into that time period exactly. 45 days means 45 days, and 3 days means 3 days. So they got the inspection. They did not provide notice of using their condition within 3 days. And express conditions have to be strictly performed, right, which can cause an unfair result, and we'll talk about waiver and exclusive conditions for that reason in just a minute. But here we have a condition that did not in fact occur, right? The inspection contingency was not used, so the condition subsequent did not operate, and since the inspection contingency did not extinguish the duty, it was not actually operated, the duty to purchase the house still existed. On the other hand, what about the financing contingency? So that was, within 45 days, they reported they could not get a loan, but they didn't try to get a loan. They didn't try hard enough. And so the main upshot from that case, other than the general rule that express conditions have to be strictly performed, is that a party who holds a condition has to make reasonable faith efforts to bring it about. And we'll see that again in the case of Hutton, especially with financing. So they have to get financing. That means they have to go. You know what? You have to schlep around. Go to a couple banks. Talk to a couple lenders. See if you can get a loan on this property. Simply failing to try to get a loan and then not getting a loan does not give you grounds for operating that contingency that you hold because you did not make good faith efforts to bring that about. And our last case on this topic is Peacock Construction, a contract to build a rooftop pool on a skyscraper. And so we have an architect, a major architect building these type of large structures. We have a general contractor, very, very large, wealthy general contractor doing massive projects at a small HVAC company. Right? Modern Air Condition is a small HVAC company, and they have a contract, and the contract says that payment, the contract calls for payment from the general contractor to subcontractors, quote, within 30 days after the completion of the work, comma, written acceptance by architect, and full payment thereafter by the owner. So the contract on its face seems to have a condition. The contract seems to have a condition that says that the subcontractor, Modern Air, gets paid when the owner pays the GC, then the GC has to pay the subcontractor. Now, that looks like a condition. It says after. But it's not totally unambiguous. It doesn't say conditions in bold. It doesn't say is contingent on. It just says after. How will a court analyze this? Well, what is the result? If did the subcontractor intend to take on this risk that the owner would not pay the GC? No, this is a small company doing a small job. They expect to be paid for their work if their work was completed satisfactorily. So what do we learn from this case? Courts will try not to construe things as conditions because the result can be very harsh. A term will be considered a promise and not a condition as a matter of law when it is commercially reasonable to construe it that way. Right? And so here the contract was susceptible to the meaning that this could have been a promise and not a condition, that it was only specifying the approximate time when you would expect to get paid, not a condition that would turn on or off my duty to pay you, because a small air conditioning company was not likely to take on that amount of risk of being paid or not based on whether the whole project was approved by the architect. They're just doing their job. And so we learned from Peacock that we're going to try to construe them this way. And we're going to get to waiver and excuse after we talk about conditions of satisfaction, because what is the court doing? They're avoiding a very harsh result. Because express conditions have to be performed strictly, it's very easy for the other party to suffer a forfeiture. And here, the HVAC company would have suffered a forfeiture. And so one solution to that is construing this to be a promise. All right, our last type of condition that we will look at that has a duty of good faith and fair dealing deals with conditions of satisfaction. These are one particular type of condition that says my duty to pay you is contingent on, is subject to, my satisfaction with your performance. And the nature of that satisfaction, whether we evaluate that objectively or subjectively, is based on what type of performance we're talking about. If we're rendering a painting for someone, right, if we're having a 20-foot tall painting on a mural on a wall, right, we might say, well, I want to approve that. I need to be satisfied on how that looks because I have to look at that every day. And the whole purpose is its artistic effect, and that's my subjective judgment. On the other hand, we might be building a barn,
right? And the barn just needs to hold animals in it. So my satisfaction should not be on whether or not the wood on every panel has, just the right grain in it. This is a barn, right? The key thing is it keep out the drafts? Does it keep the animals in? Is it secure? Is it sturdy? So whether it's an objective or subjective condition turns on whether it's a commercial or a matter of judgment, taste, or fancy. So let's talk about the case of Hutton v. Monogram Plus. So plaintiff purchased a franchise business to make monograms from defendant, and defendant agreed to provide licensing and a 10-year exclusive to operate and market sales in a particular area, but there was a requirement on the other party to purchase this Meistergram 800 XLC monogram machine, and defendant advertised the total cost of the entire deal, including this lovely Meistergram 800 XLC, should cost less than $40,000. But when push came to shove, that advertisement did not hold up, kind of like when you go to get that car that says 0% APR and say, oh, well, not for you, you can pay 7%. That totally changes the cost of financing. They had trouble getting good financing, and so the cost of this machine alone was $45,000. Right, and so we have a $45,000 machine. He expected to pay $40,000, and we did have a condition in the contract that said Hutton has the right to get financing satisfactory for him. Financing satisfactory to him, he said that's too expensive, it's not satisfactory to me, right? So what result? Does he get to unilaterally decide what financing terms are satisfactory to him? No, he does not. An objective standard of commercially reasonable applies. And the court finds that he did not, two things went wrong in Hutton, right? Good faith and fair dealing did not occur because he did not make reasonable efforts to find better financing. And we know from our prior cases you cannot stand on your contingency when you do not make commercially reasonable efforts to bring it into existence. If you have a condition, you have to try to bring it about, or you can't rely on it. Also, whether or not you like the financing, this is like the case where someone gets a delivery of pig iron, which is used to melt into beams, and says, I don't like the shape of the pig iron. You're going to melt the pig iron down anyway. You're going to melt it, It's not an artistic thing. Who cares about the shape? What you should care about is its composition. Is it the right mix of whatever things go into steel, right? Or, it's not about the shape of them. Sure, if they're so big they don't fit in your melting machine, that's an issue of not being commercially reasonable, but not being pretty. Likewise here, the financing wasn't so pretty. It was higher than he expected, but it was within commercially reasonable standards. And so he was, in fact, not able to exercise his contingency because although he was not personally satisfied, objectively he should have been satisfied. And so he is in breach. He had a duty he didn't perform. He is in breach. Similar happened in Morin Building Products, but it was a little more complex here. Here we have a contract that says the exterior, we're going to build an extension to a Chevrolet plant, right? They're making these lovely Corvettes, and you see how long that production line is. They want to make the production line longer, so they need a bigger building. And they want this building to look like the rest of the building. That makes sense. People are driving by. You're driving on Interstate 76, and you pass by the Chevy factory, and it's very pretty, and you think, what a pretty factory. I'd love to buy their cars. Or what a grungy factory. They must make terrible cars. So maybe they have some reason to want this building to look pretty good. But then again, what is this building? Effectively, it's a warehouse. It's a commercial building. Now, the contract did say, we should always read the contract when talking about contract interpretation, all work shall be done subject to the final approval of the architect or General Motors authorized agent, and his decision in matters relating to artistic effect shall be final. Artistic effect, right? If within the terms of the contract document. Now, this was a hard one. This was a close case because it did imply that we could say, well, this did not meet our standards of artistic effect because at the end of the day, they didn't like the shininess of the building. They did it with aluminum siding, and it wasn't quite the right shininess at dusk. Okay, it looked pretty good. It was milled. It had a nice stucco finish to it the way it was specified, but at dusk, it was a little too shiny. Well, it was new, right? Of course it's going to be a little too shiny, and they found it would be very, very hard, nearly impossible to make it match exactly. How do you take a piece of brand new aluminum and make it look exactly like an entire factory worth of 15-year-old aluminum? Virtually impossible. Is that what they really wanted? Well, they did say artistic effect, and it did seem to imply that. However, there was that other provision if within the terms of the contract document. So what does the court say here? Look, this is still a commercial deal. This is sort of pushing it, right? We're right at the edge here. We do have some implication that this could be seen subjectively, but an objective standard applies to conditions of satisfaction. In commercial dealings, right, just like Hutton, they're going to go a little farther unless the parties unambiguously agree. Otherwise, see the case of Ard for an example of where parties expressly agreed otherwise. And why are we doing this? Just like in our prior case where we interpreted something as a promise instead of a condition, we're going to do this because otherwise we can get an unfair result. So when are we going to use an objective standard? We're going to use an objective standard for conditions of satisfaction for something of commercial value, commercial quality, operative fitness, mechanical utility. On the other hand, when are we going to use a subjective standard? Well, when we have something of fancy, taste, personal judgment. There's another case where someone asked to have a bird bath built in their backyard. And their specifications for this bird bath was going to be 15 feet high and bright purple, right? That's the ugliest bird bath in the world. The person refused to build it that way. He built a much more reasonable looking bird bath. And the contract had a condition of satisfaction and said, I'm not satisfied with your attractive bird bath. I wanted an ugly bird bath. Do I have the right to refuse to pay because I didn't get the ugly bird bath that I wanted, that your bird bath is not ugly enough? Well, in this case, that was meant to be a statement piece, right? I want a giant 16-foot tall purple bird bath in my backyard, right? And so that's what I'm going to get, or I'm not satisfied. That wasn't something of commercial utility. That was of personal taste. Personal taste can vary. I might happen to think a 16-foot bright purple bird bath is quite beautiful. I'd be wrong, but objectively wrong, but I would be in my right to not pay under the contract. And what do we ask? If it is objective, we ask, would a reasonable person in the position of the obligor be satisfied? If it's a subjective standard, we ask, was the person actually satisfied, and again, in good faith? Right? Are they actually unsatisfied, or are they just trying to get a better deal? Are they trying to cheat? We still have that backstop of the doctrine of good faith and fair dealing. And we do this because conditions are really difficult. They can cause forfeiture. Conditions can cause forfeiture, and so courts will sometimes waive a condition. So a court can do several things. If there might be forfeiture by one party because a condition was not strictly performed, a court could, A, say that it's not really a condition. It's a promise. And so it's a promise, and so we both have to perform, and you can sue. That's a less harsh result. They might read the condition, for example, a condition of satisfaction, to be easier to satisfy. An objective condition is easier to satisfy than a subjective condition, so we can make a condition easier to satisfy and then satisfy it. That avoids a harsh result. Or, if all else fails, a court might waive it because it is a matter of injustice if it were to be enforced, and that's when we talk about forfeiture. The restatement talks about this and says that to the extent the non-occurrence of a condition would cause disproportionate forfeiture, one person's going to do fine, the other person's going to be totally hosed, right? A court may excuse the non-occurrence of that condition unless its occurrence was a material part of the exchange. So let's take a look at a case that interprets that. So Chelsea had a 24-year lease from J&A. 24 years is a long time. And why might you have such a long time? Well, Chelsea ran a restaurant. And restaurants get a lot of value out of staying in the same location. You make a lot of investments into your restaurant. You make investments in advertising. You make investments on being at the right spot on Google Maps, in your search engine optimization, in painting the walls. And every time you change hands, there's a certain cost that can come about. Now, landlords could do something. They could take advantage of the situation. It's called a holdout problem, because if you would have to spend $100,000 to move, the landlord could jack up your rent, and you would pay more to stay than someone else would pay to live there. And so they might be able to extract more rent from you. So we do have some laws about that. But one way commercial parties protect themselves is by having long-term leases. In this case, the long-term lease had a provision that you had to give 6 months' notice to renew. So a condition of renewal was 6 months' notice. That is an express condition. It has to be strictly performed. Time is of the essence, just like we saw in Peacock. But what happened here? They didn't do it. And why didn't they perform within 6 months? They didn't actually have a good reason. This is kind of a weird case in that regard. They didn't have any particular good reason. They were just kind of negligent about it. But the court found that it wasn't a big deal for J&A to maintain the lease, and it would be a horrible thing if Chelsea was kicked out. And so the court here decided to construe this as a promise to give notice within 6 months and not a condition, even though, courts they waived this, or they would alternatively construe it as a promise and not a condition to avoid forfeiture. So at the end of every lesson, we always have this concept of good faith, and that always brings us to our equitable relationships. And so at the end of the day, there's always this equitable backstop. We learned a bunch of laws. Right? What did we learn today? We learned that courts will interpret contracts to determine parties' intent. What do they say? What do they do? They will begin with the four corners of the contract, and they will apply the canons of construction to determine the express meaning of those intrinsic terms. That may fail, in which case they have to go to extrinsic evidence, things like course of performance, course of dealing, and usage of trade. They also might ask the parties parties might ask to admit evidence of terms that were not in that contract and are not part of usage of trade, but things they agreed outside. That's the parole evidence rule. When do we admit that? We can admit additional terms for a contract that was not integrated. We can admit additional terms for a contract that was partially integrated. We can admit nothing for a contract that was completely integrated, although if the terms are collateral to, separate from, not expect to be part of the original agreement, then they can come in because they wouldn't be even in a complete integration. Now, parties might not say everything that they meant, and so some terms are implied. They can be implied in law, they can be implied in fact, and one of those big ones is the duty of good faith and fair dealing, which is implied in every contractual relationship. So we have to begin with mutual promises, right? If they, conditions, right? So when we talk about conditions, the first thing to think about with conditions is this a condition or a promise? If it is in fact a promise, it has to be performed hell or high water, right? Otherwise there is breach. On the other hand, if there is a condition, the non-occurrence of that condition is not a breach, but excuses the other party's performance. If it's interpreted as a promissory condition, it both excuses the other party's performance and allows a suit for breach. And courts may excuse these conditions when forfeiture results, or they may try to contort that condition into something like a promise, or they may make it easier to satisfy that condition in interpreting a contract. And so that is your review of contract interpretation. Thank you. All right, so after this, you have a nice long break. I hope you enjoy.